marijuana. Marijuana is a tricky subject in Indiana. Some forms are legal, but others aren't, and that distinction can very quickly get people into trouble. What about Delta 8 or Delta 9? Is it a legal high or is it a legal risk? Today, we're breaking down Indiana's marijuana laws, the difference between Delta 8 and Delta 9, and how one court case heavily affected how the law in Indiana applies to marijuana. Let's start with the basics. Hemp and marijuana are technically both part of the same species, Cannabis sativa. The big difference? The THC content. Hemp has 0.3% or less THC in it, meaning it won't get you high. Marijuana contains more than that 0.3% and is the stuff that will get you high. Think of it like dogs. It's the same species, but very different breed characteristics. You're not going to confuse a Great Dane with a Chihuahua. Delta 9 THC is the most well-known psychoactive compound. It's what gives you that really intense high. Delta 8, it's a milder version of that. Both are chemically similar but affect your body differently due to one tiny change: a double bond on either the 8th or the 9th carbon atom. Delta 8 versus Delta 9. In 2018, Congress passed the Farm Bill. It's a federal law that legalized hemp and any derivatives with less than 0.3% THC, specifically Delta 9 THC. That's the key word. Delta 9. It only bans Delta 9. Delta 8 is a derivative of the cannabis plant, which is often synthesized from legal hemp. So technically, Delta 8 is legal federally. Indiana law mirrors that federal farm bill. Hemp-derived products are legal if they contain no more than 0.3% Delta 9 THC and are not deceptively packaged or synthetically altered. There are 3 relevant codes that we're going to be talking about here: possession of marijuana, dealing in marijuana, and possession of paraphernalia. Possession of marijuana is known as Indiana Code 3548-411. It's a Class B misdemeanor if you're caught with marijuana in your possession. This charge gets upgraded to Class A if you've got prior drug offenses, but it gets upgraded even further to a Level 6 felony if you get caught with over 30 grams and you have prior convictions. Dealing marijuana is known as Indiana Code 3548-410. It's a Class A misdemeanor for basic dealing, but there can be felony charges based on the amount, criminal history, and packaging of the marijuana. Possession of paraphernalia is a Class C misdemeanor, but it gets bumped to Class A if you have prior offenses. That said, to actually convict someone of marijuana possession, the state must prove 3 things. Number 1, they must prove that the possession was knowing or intentional. That means that the person had to have control over it. This can be actual, like if it's in your pockets, or it could be constructive, like if it's in your car or in your room. Number 2, the substance has to be marijuana, and this has to be proven by testing. Hemp isn't illegal, so prosecutors need to show THC levels exceeded that 0.3% marker. And number 3, possession was unlawful. Now, this one's a little simple. Indiana has no medical marijuana law. There is no exceptions. They're always going to prove that it's unlawful. That said, in Marion County specifically, simple possession of under an ounce of marijuana is rarely prosecuted. But remember, it's still legal. It's just a policy choice. It's not the law. Since we're on the topic, there's one case in particular that stands out here: Fettage v. State. On February 27th, 2020, Officer Shelby Jellison of the Carmel Police responded to a disturbance at a residence where Fettage was living. Upon entering, the officer smelled burnt marijuana or hemp coming from Fettage's bedroom. After Fettage refused consent to search her room, Officer Jellison obtained a warrant and found various items. These items included plant material, THC-labeled candy packages, liquid packages, smoking devices with residue, and other marijuana-related paraphernalia around the house. The state charged Fettage with multiple misdemeanor counts for marijuana possession and paraphernalia. During trial, Officer Jellison testified that she smelt burnt marijuana, but admitted that she wasn't trained to distinguish it from burnt hemp. Lab testing was necessary to determine THC content, but instead of lab results, the state relied heavily on the packaging. This included stuff like THC infused, or 100% dank, or THC 80 to 85%. But here's the problem. The Court of Appeals said that's not enough. The packaging alone wasn't trustworthy evidence. Now, why is that? Because unlike regulated medications and pharmaceuticals, these labels weren't verified, they weren't approved, and they could be exaggerated. Without lab results, there was no actual proof that Fetich possessed illegal marijuana instead of legal hemp, so the conviction was overturned. The state needs a lab test to properly prove a marijuana case. So what's the lesson here? In Indiana, marijuana is still illegal, but hemp-derived THC, like Delta 8, is kind of in a gray area. If you're caught, prosecutors still have to prove that the THC content is above the legal limit. Labels aren't enough. Delta 8 isn't illegal, but it's still risky. So don't rely on packaging and know your risks. If you have any questions, please give us a call at 317-632-3642. And remember, always plead the fifth.